All right, so my name is Justin Stivers. I am an attorney. I'm the owner of the Probate law firm. My office is in Brickell, but we're pretty much statewide. We have active probates in about 17 different counties right now. So I know we've got your title person. I don't do any title, so all we do is probate and estate planning. I don't do real estate. I don't do landlord-tenant. I don't do evictions. I don't do any of that. So we're very hyper-focused, hence why the name of the firm is called the Probate Law Firm. It's the only thing that we do. And so I started doing this kind of presentation several months ago because I saw sort of a lot of realtors are coming across probate properties either on the buyer side or on the seller side, and it's kind of it's not a new area, it's been around, but I think with South Florida, an aging population, we're going to see a lot more and more of this. So my goal here is really threefold. I just want to kind of give enough information so that you guys can identify when a property may or may not need to go through probate. Give you enough information so that you can, when you go into a listing presentation, let's say, you have enough information to sound like you know what you're talking about. Again, you guys, I mean, if you're an attorney, then you maybe can talk a little bit more, but most realtors don't know what a decedent is, what a last will and testament, or can't talk about it in a way to really show that you know enough about probate. And hopefully this presentation will give you enough knowledge so that you can just talk with your potential seller and stand out from your competition. And then lastly, just give you a couple marketing ideas, because at the end of the day, it's about making money and trying to find listings. And I think this is going to be a growing niche to get into. So for some of the newer realtors, this might be a good area to try to pursue. So I usually like to start the presentation by going around the room, introductions, but I know I want to get you all out of here on time. What time do we have? Until 11:45? Yeah. Okay. And we've got a bigger group, which is, I was telling Odie, which is fantastic in the summer and everything, which speaks to you guys really getting out there and hustling. But maybe just, instead of going one by one, maybe show of hands just to kind of gauge who we have here. How many of you all have been a realtor for under 2 years? No more than, okay. All right, so just 2 years? Okay. Who's been a realtor for more than 5? More than 10? 15? 20? We'll stop there. Okay, so we got some very experienced realtors in the room. How many of you all have dealt with probate either on a personal or business side? Okay, both. All right, so a fair amount of people. Good or bad experience, awful experience, slow, went okay?
Slow,
okay.
awful, the courts are horrific.
Okay, so that's generally the response. And yeah, so probate does, I think, have a bad rap. Sometimes it's warranted, sometimes it's for lack of somebody not doing their job, or siblings fighting, or a whole host of things. But I don't want to scare you guys away from it, because again, I do think it is an opportunity to get into. All right, so just to start, let's start with a couple definitions, working definitions of what probate is, and some other key terms that I think you all will use in this type of real estate. And some of this might be very basic. I know, show of hands, it seemed like almost all of you have dealt with probate, so I apologize if this seems very basic, but it is Probate 101, so I'm trying to keep it as simple as possible. So the first definition is probate. So probate is basically a process that happens after somebody has passed away. So the kind of the triggering event is someone has died, and then it's going through a court, it's going through the courts, you're dealing with judges, you're dealing with attorneys, and you're basically taking whatever someone had when they were alive, now they've passed away, and you're transferring it to whoever's going to inherit that. So in your all's world, in real estate, it's basically taking a house that was owned by somebody while they're alive, now they've passed away, and now the courts have to say essentially who the new owner is. So that's kind of, when I think of probate, I just think of taking something that someone had when they were alive, now they've passed away, and then transferring it to whoever the new heirs are. Next, and if you guys at any point have questions or want to shout out, small room, feel free to just shower me with questions. Decedent So the decedent is just another name for someone who's passed away. Again, that's just kind of a legal term that we use. Decedent, just someone who's passed away. Estate, E-S-T-A-T-E. Estate is what we call everything that somebody owns. Now that they've passed away, it's their estate. So let's just say when John was alive, he had his car, he had his house, he had his bank accounts, he had his, whatever else he had. Now that he's dead, we refer to everything that he had as his estate. So again, common word that you all use. Last will and testament. Who knows what or we call it a will? Who knows what a will is? Yes, ma'am. What is it?
It's you have to put down your instructions as to what you want to happen with your estate.
Perfect definition. Yeah, so it's basically a piece of paper that says who gets what after you pass away. Okay, that's what most people think of it as. So you might say, I leave my house to my daughter, I don't leave it to my son, or whatever you want to, however you want to do it. I've seen it many times. I've seen a lot of stuff like that. Two other reasons why a will are really important. Most people think of a will as just, I want to leave my stuff to this person. There's two other reasons why it's really important. For people with minor children, for people who have kids under 18, it's very important that you want to put in there, if something were to happen to you or your spouse, who's going to take care of your children? Because unfortunately I've seen where the parents pass away, and then you've got fighting both sides trying to figure out who's going to take care of the children. And so a will can take care of that. You basically say, I want my in-laws, I don't want my in-laws, whoever to take care of the children. It also names the personal representative. So that's the last definition that we'll talk about. A personal representative, that's what we use in Florida. Some states use the term executor. New York uses executor, but they mean the same thing. It's personal representative / executor. Means the same thing. And that's just the person who is in charge of managing the affairs of your estate. It's the person who is appointed by the court. They get a piece of paper saying that this person is now the personal representative. That's very important, and we'll talk about that here later in the presentation. But that's the person that you, as a realtor, are going to be working with if you're selling the property. Only the personal representative has the legal authority to sign closing documents and sell the property, get into the listing agreement, and all of that. In the will, you name who your personal representative is going to be.
Is that like
Yes,
a
ma'am.
trustee? Or no?
Yes, it's similar. It's similar. In a trustee, that's when you create what's called a trust, and then you have the trustee. But yeah, they're essentially the same thing. So the personal representative, and that's really the person that you'll be working with, and that's why again it's important to have someone named in your will as who you want to manage, everything after you've passed away. Okay. Oh, and then one last thing about a will. So a common question I get is what if you think someone had a will but you can't find it? There's not a database that I or anybody can look into to find out if the person had a will. Most wills, for example, I could write on this piece of paper, and there's a couple requirements. It needs to be witnessed by 2 people. We all need to sign it. If it was done properly, I could just take this piece of paper, give it to Odie, and she has my will. And then when I pass away, if no one knows that I gave it to her, no one's going to know that I have a will. So a lot of times I'll get asked, well, I think, my parents, I think they did a will, we just can't find it. I can't, do www.will.com, search. There is probably a will.com, but you wouldn't be able to locate the will. So that's just something I get asked a lot. Yes, ma'am.
When you're dealing with a personal representative, they should provide the document, shall we say, that is naming them, the personal representative?
Yes, and I'll touch on that. The will is going to name who the personal representative is. Okay.
So would we get a copy of the will, or would
Well,
we
you
get
might
a
not.
certificate of naming that
No.
person?
A person does not become a personal representative until the court says they are. So you, as the realtor, you might get the will, but that's not good enough. You need an order appointing personal. You need something from the court.
Exactly.
So it's not good enough that John just says, hey, here's my parents' will. They name me personal representative. That's not good enough. You need to wait until the attorney or whoever gets you the order from the court. Okay. So any questions? Those are, you know, the most basic type of words, language. Some of them, you know, you all have heard before, but some of the words that we'll be using. All right, so what's one of the, when someone says, hey, you know, Justin, I've got a friend, they want to sell their property, what's the first thing you all do?
See who owns it.
See who owns it?
Right.
Okay, so you maybe go to the property appraiser, tax roll, to
Right.
figure out who the owner is. Okay, so that's, this first kind of section is to figure out how can you all determine whether or not probate is necessary. So this is a question I get asked a lot. A realtor might call my office and they'll say, hey, you know, something looks a little funky on the property appraiser's website. What does this mean? So this is to kind of give you an idea of when at least you think that probate might be necessary. So you have three printouts. So the first one let's look at is property address 11309 Southwest 200 Street. So in this one, if you look just under that, the owner is Maria Pichardo, and after that he says EST of. Okay, so what that stands for, state of. That's the, no pun intended, dead giveaway that this is going to go through probate. So anytime you see that, 95% of the time it's going to go through probate. Now, it's possible that the probate might have finished and they just haven't transferred title. That is a possibility, but that usually happens pretty quickly. So if you see this, this would be your first indication that the property, a probate needs to happen before you could buy or sell this property. Okay, so that's the easiest way to figure this out. That's probably the most common thing you'll see. All right, let's look at the next one, 1821 Northwest 33rd Street. So this one has two owners. So you see first one that says Jesus Silva, EST of, which we know it's owned by his estate, and the second one is Maida Silva. So this is an interesting one, and this happens a lot, and this is one that we did. And so what happened was Jesus is the father, Maida is the daughter. They own the property, and I'm not going to get the title, but tenants is common just basically meant that Jesus owned 50% of it, and Maida owned 50% of it. But she's the only daughter. He passed away. She thought she just automatically inherited the property. Didn't have a will. So she gets a realtor. They get a listing agreement. They go to sell the property. It took like 4 or 5 months. They go to the title. Title says, no, you got to do a probate for Jesus. And she was obviously, you know, kind of aggravated that they'd spent 4 or 5 months going through this process. But this happens more than you would think. She just thought, I'm the only child. I'm already on title with my dad. He told me I get the property, so she just thought that she'd get it, that she would inherit the property. But so we had to do a probate. Took a little bit of time, and then she got the property 100% in her name, and she was ultimately able to sell it. But if you see on there 2 owners that look like this, generally that means, again, you might want to look at the title and ask your, Elizabeth, ask Elizabeth to look at it. But generally that's going to mean that the property is owned 50-50, and you have to do a probate for the person who passed away. Any questions? Or just what's that?
Tenants in common.
Tenants
Tenants in common.
Tenants in common? Oh yeah, tenants in common. Yeah, they had it. Tenants in common.
They didn't have a right of survivorship.
No.
It would have eliminated.
Yeah. So, great segue. So generally, there are ways to avoid probate. One of them is that joint tenants with right of survivorship. Again, I don't want to get too much into that, but that just basically means if you have that language in the deed, the property automatically passes to the surviving person. So if Jesus and Maida, if on their deed it said they owned it as joint tenants with right of survivorship, then when Jesus passed, his interest, his 50% ownership would have automatically passed to Maida. Good question. So another way to avoid probate is if we look at the last one, 13926 Southwest 161st Court. So this one, you can see the owner is Karen S. Rodman, and after that it says TRS. So what that means is the property was put into a trust, right? So a trust is a separate legal document. And one thing very important, people will do a trust, but they don't do a new deed, and then that doesn't put the property into the trust. So in this case, it was done correctly. Karen created a trust, she renamed the deed, or she did a new deed and put the property into the trust. The beneficiary is Karen Rodman, which is the beneficiary. So when Karen passes, this property automatically goes to her beneficiary. That's what BEN stands for. And so this won't go through probate. And so if you see this, and I get asked this a lot because a lot of realtors don't come across it too much, but if you see that TRS, it generally means trust. So there's a trust document, and it's not going to go through probate.
Question.
Yes, ma'am.
Revocable trust.
Same thing.
Same thing, it goes and they don't have to go to probate.
Yeah, if it's done correctly and it's got the
And it's
TRS on there,
deed.
yeah. One big misconception, having a will does not avoid probate. Okay, so I get this all the time. I've seen people, they'll go to the courthouse or wherever, to change the deed. They bring the will, they bring the death certificate. They say, look, my dad died. He left me the property. I'm the owner, and the court's going to say, no, you need to go through probate. So having a will just by itself is not going to avoid probate.
Husband and wife.
How can you?
Husband and wife would avoid probate. Yeah, because that would just pass automatically. So the best way to avoid probate is either the trust or having the deed done correctly. There's a couple different types of deeds you can do. The joint tenants with right of survivorship. If you all have heard of the Ladybird deed, enhanced life estate deed.
Just sold the house I had.
Yeah. So that's one way to do it as well. Those are probably the easiest ways.
Or having a beneficiary.
Yeah, and if you have a trust, you have a beneficiary. Yeah.
I think just in general, because of the questions that come to me
Sure.
from many
That was great.
realtors,
Yeah.
is asking the questions. When you see something like
Right.
that, ask the questions, because then that'll help you know, okay, where is this headed?
Yeah.
How long could this take?
Yeah, and I'm going to talk about that as well. And I think that's one big takeaway from the second one we looked at with Jesus and Maida. I'm sure the realtor had good intentions, but had she just, looked at that, she would have, or asked, that's why the point of this course is not to tell you how to do probate, because that's not your job, but your job is to kind of set everyone off on the right foot, on the right path, and you don't want to waste the client's time. And had she, when she learned that, when she knew that Jesus had passed away, she could have said, hey, what does this mean? What's the next thing I need to do?
Plus, when you get a listing agreement, you have to, it has to be, you have to have proof of,
Right.
death
Ownership.
certificate and all that.
But
Yeah.
that's the perfect time to be asking the
Yeah.
questions.
Yeah.
When you see that, okay, what happened here? Right.
Who's gonna sign it?
Exactly.
Otherwise, you're not selling it correct.
Right, exactly.
You can't even list it.
No?
Yeah, you could, and we'll get into listing and how to sign everything in the contracts and whatnot. But I guess this first section is just to, if you see something that looks a little fishy, ask Elizabeth or ask your attorney or whoever. Just say, hey, is there something else I need to be aware of? Don't just jump into a contract. I know it's easy. Same with me when I see a client, but I know they're crazy. It's like, do I really want to take that case? I want that money, but I know they're going to be a headache. Kind of same thing with you all. If you see something, it's better as opposed to just getting into that contract. Just do your due diligence and then sign them up. All right, so that's how to, basically the property appraiser website. Or the tax roll. That's the best way. But also in speaking with a potential client, you can ask them questions as well to determine whether or not it's going to go through probate. Obviously, if someone says, hey, my friend's mom just passed away, bless you, that would probably, set bells and whistle off that this might be a probate listing. All right, so part number 2. So you've determined that it's going to go through probate. You're setting a listing, presentation. You go there. So I always tell realtors there's probably two questions you want to ask. And when you know it's a probate listing, the biggest issue one of the biggest issues I see realtors run into is that they're not speaking with the right person. They're not speaking with the personal representative, which we spoke about a second ago, where that person is the person who will be able to sell the property. Sometimes people think they're entitled to sell the property when actually they're not. And so we'll talk a little bit about this, but these questions I'm going to give you are to make sure that you're speaking with the right person so you don't waste your time, you don't waste their time, and it's just a headache. So first question I always suggest that realtors ask is, did the person have a will? All right, and we spoke about that because a will is going to say usually who's going to get that property. So and again, I know it's kind of joking and also kind of sad, but I see a lot of times where a will say, I leave everything to this child, I specifically don't leave anything to this child, or spouses sometimes. You can't really do that, but sometimes people will try to leave their spouse off, or instead of leaving to their children, they'll leave it to their brother or sister. So it's not just, we know not everyone's has good family relationships. So if you're speaking with this, let's just say the daughter, and there's a will, you want to say, hey, is there a will? Because you want to make sure daughter is actually going to be inheriting the property.
I have a question.
Okay.
Let's say you come across one of those crazy families
Mhm.
where the father decides he's not leaving anything to his children and it's, a multi-million-dollar estate. Do they fight that generally, or can they fight that? Can they win that?
Yeah, people fight it all the time.
Okay.
I would say in my world, the biggest thing I see is when you have two wills. So someone might have done a will at one point and then changed it, or we're arguing over whether or not it's legitimate, whether or not the person actually did it. That's number one. The second thing is usually if the person who did the will was maybe sick, had Alzheimer's or something like that, or just wasn't stable.
Yeah, just not stable.
It happens. I mean, yeah, I would say, and yes, in the big money cases, it definitely, the biggest states, it does happen. I actually see here more over small things, because a lot of times you have sibling, as people grow older, siblings kind of tend to grow apart a little bit, and maybe brother was taking care of dad while he was sick and sister wasn't around, and now he's resentful that she wasn't helping, and so you have stuff like that. So it's not uncommon, but I would say probably like 70% of our cases, they're relatively smooth. It's not fighting, but yeah, that's why talking about wills, that's one thing I see a lot of in today's world, you can download a will off the internet, you can go to Office Depot, there's LegalZoom, there's a lot of like do-it-yourself type wills, which they're not all bad, and some of them are absolutely fine, but obviously there are like certain requirements, and so sometimes I'll see that, where now maybe we or they are saying the will is not valid, it wasn't done properly. So that does happen.
Okay.
Yeah.
Thank you.
So you want to ask, is there a will? Make sure that you're speaking to the right person. The next thing you want to say, if they say yes, there is a will, you want to say, do you have a copy, or can you get a copy? And as crazy as it sounds, some people, like I was saying earlier, there's no master database where we can just find a will, but sometimes people will say, oh yeah, my mom wrote this will, leaving everything to me, I'm just not sure where it is. Well, if they can't find it, I can't find it, and it's not going to be valid. So, and that happens a lot where people will swear up and down, I know they did it, I took them to the attorney's office, but the attorney doesn't have it, kind of out of luck on that one. So question number one, ask if they had a will. If there was a will, question like 1A, can you get a copy of it? All right. The next question that I would ask is, what's your relationship to the person who passed away? Meaning, was it your father? Was it your brother? Was it your grandfather? What was your relationship? And the reason is, especially here in Florida, you have a lot of individuals who are maybe close with their, maybe brothers live together, cousins live together, whatever the case may be. And in Florida, there's a hierarchy of who's going to inherit what. So basically, first your spouse gets everything. If there's no will, this is kind of the hierarchy. First the spouse gets everything, then the children get everything, then the parents get everything, then the brothers and sisters, and then it just keeps going until you get out to like second, third, distant cousins. But again, I would say like in Florida, you have a lot of like cousins who are really close, or even brothers and sisters who are really close maybe. The further you get out in relationship, the less likely they're going to be inheriting anything. So if you're speaking with an aunt or an uncle, that means you've got to first find out that there were no children, that there were no parents living, that there were no, there's kind of a hierarchy. So that's why I always say, find out what the relationship is, just to kind of have an idea of who you're speaking with. Make sense? All right, and again, we talked about a will is not going to avoid probate, so it's a great document to use, and a will, you can specifically say who you want to inherit something, but it's not going to avoid probate. All right, so now they're ready to. This is maybe the more technical thing. So now you've spoken with them, and I guess one quick side thing. It's not really your job to determine whether you're speaking with the right person, right? You all are probably going to bring in an attorney at that point, and the attorney will be able to, more so determine to make sure you're speaking with the right person. But this is just kind of helpful things that you can kind of ask. Again, it makes you stand out from other realtors, because I guarantee you most realtors, when they go to a listing presentation, they're not asking these types of questions. So it's just kind of, I think, getting your foot more in the door so that this potential client will hire you, right? But let's say at this point, okay, we've determined that you're speaking with the right person. They are going to be the personal representative. Now how do you do this? The first thing you're going to get is a listing agreement, right? So you need to get them, under contract. And here is where I've spoken with, you might have a different take on this, but this is speaking with different brokers. What I always recommend, this person, until you get a piece of paper from the court that says order appointing personal representative, this person doesn't have any authority to sign anything. Okay, so even if they have a will and it says Justin Stivers is appointed personal representative, or I nominate Justin Stivers to be personal representative, that doesn't mean anything until the court says that I am. All right, but there's probably going to be some time in between you getting a listing agreement and there being that piece of paper. So you obviously don't want to lose out on this client. What I recommend, again, subject to your boss here, what I recommend is you put in the listing agreement, you say Justin Stivers as proposed personal representative.
Oh, I like that one.
Okay, so they're not personal representative yet, and you cannot put it on the MLS yet. At this point, you can't put it on the MLS. You can't list it or do anything with it yet. But you can at least say you believe Justin Stivers is going to be the personal representative. You have a listing agreement, and you're signing him up as the proposed personal representative. And you're doing this for a couple reasons. One, you want to protect yourself. You don't want to do something that's in violation of real estate laws. But you're also protecting this person, because this person doesn't want to be on the hook for something that he doesn't even have the authority to do. Does that make sense?
Yeah.
Okay. So then the next stage, the next part of it would be, all right, and I'll talk about how, time for getting that piece of paper. But the next stage is, okay, now you've got myself appointed as personal representative. Now you can start marketing. Now you can put it on the MLS. Now you can, I would probably even say, update the listing agreement to say Justin Stivers as personal representative, just, for your records. But when you go to sign any contract, the personal representative should not sign it in their own, by themselves. So I don't want to sign it Justin Stivers is selling it, because it's not my property. I don't own it yet. What I'm going to do, how I'm going to sign the contract, is I'm going to put Justin Stivers as personal representative of the estate of whoever's passed away. I know it's like a super long phrase, but so let's not use my example, because I don't want to think about someone dying. But let's say John's parents dies, John's mom dies, Sarah dies. So you would sign the contract as John Smith as personal representative of the estate of Sarah Smith. Okay, and that way, again, this protects you, this protects them, and the reason is, again, John doesn't own this property yet. He's just the personal representative, the one authorized by the court to sell it or do anything with it. If for whatever reason the property doesn't sell on time, the buyer gets angry, wants to come after you, you don't want the buyer coming after John individually, right? You want him coming after the estate, have him come after the estate. That's where, we would deal with it. You don't want him being able to sue John individually. So I know that's a little technical, but that's probably the most technical part of this. Yes, ma'am.
So let's go back to as proposed personal representative, when he signed the listing agreement, does that mean that then the listing agreement you can't?
There's no listing agreement.
You still can't put it on the MLS.
No,
Right.
can't put it on MLS.
But you have a security that you're gonna get the listing until they get it approved.
Right.
And
representative.
But there is a listing
No,
agreement.
no, because
No.
the listing agreement says that you have to put it in the MLS within, 48 hours.
Uh-huh.
So, no, because you can't put it in the MLS.
So where's the hook?
So do you say
It-
then
it
Have
that
a
it,
listing
the
agreement
sellers know.
signed, hopefully they're not gonna go to Caldwell Banker and meet with someone else and
Right.
sign another
Yeah,
listing
it's,
agreement.
there's no like, there's
But
no
there really
perfect,
is no assurance.
there's no perfect way, because it's not really, I didn't know that you had to put, I know the listing agreement said you have to put in 48 hours, but, okay, so, it is kind of just assurance between you and them that they are using you, but until they're personal representative, there's not really anything legally binding them to, cause they
It's
can't do
employment.
anything yet.
can you say
I think
that
it
it'll,
gives them some sense of ownership.
Yeah.
Oh, okay, I'm I've committed to.
Yeah.
But
I have to
pending
wait for the order.
confirmation by the court,
Yeah, right, if you put it
Await.
in the
Yeah,
additional.
sure, you could do
awaiting
that.
confirmation by the court, and then.
And you still can't put it, you're not an
It's
attorney.
not legal until you
Just
change
do
it.
what
The
you
attorney
suggested
has to
and
do
that's
it.
it.
You can't do it.
Yeah, I mean, this is not like a self-promotion, but yeah, maybe you do wanna use an attorney to write it, but I've seen literally hundreds of these, and whenever a realtor asks me, I say put the proposed personal representative part, and I've never had, knock on wood, I've never had an issue with it yet. And I've been like telling a ton of realtors, so I'm either gonna get in trouble or I've seen.
No, but it's fine,
No,
just don't put
it's
it in the
fine,
MLS.
because you don't
I don't let them
Yeah.
put it on the MLS like like that.
Yeah.
Until you read the order.
Yeah.
Until I have something, I don't do
This
the order.
goes in your drawer until
Yeah.
you get that order.
It's just
And,
an
and
agreement.
it's not, so, and I'll talk on like, time, but chances are, once they've signed that, they're not thinking in their mind, oh, I need to go find somebody else. They're gonna use you, and they're probably now speaking with the attorney, and so they're invested, like, they know what's going on. But I see your frustration, I don't have a better answer for it.
Yeah, we just have to wait.
Yes, sir.
Actually, you have a valid contract.
Right.
Right.
So it's still required to be listed?
Yeah.
Yeah.
No, you cannot put it in the MLS.
Right, so you can do both.
I mean, I like his suggestion because it gives them a sense of like, I don't need to meet with other realtors, I've already committed to this as soon as the courts are done,
Yeah.
so,
Yeah.
But then they do sign the listing,
not
no?
later.
I'm saying, have them
You
sign.
can sign it, but you
Sign
can't do
as
anything with
Yeah,
it.
you can have him sign it, but
Right.
you put it on the MLS.
Or, I mean, if you feel bad, you could literally say, you could just give them a blank piece of paper, say, I am going to use this person, and then wait 3 or 4 weeks until we get the personal representative. But that's why I say the listing agreement has like a little more, it makes them feel a little bit more invested.
Sort of
You got a question?
yeah,
Howard.
why can't you just say it'll become effective upon the letters of administration being issued or
Yeah.
whatever?
You could,
Yeah.
yeah, you
Yeah,
could,
you could do
that.
I have no problem with that. Yeah, I'm trying to keep it basic, but yes, there are a bunch of different types of language that you could put in there. Again, my experience, of doing a lot of these proposed personal representative has been
I think
enough,
that's what we did.
and I've never had
It was
issues.
horrible.
He
You
had
know,
a
this
big-
is how we distributed funds?
Yeah, we basically, that's what we did, we just put, upon approval of the board.
Yeah.
We still haven't distributed funds.
We can talk.
Horrible.
Yeah.
I have a question, what
Yeah.
happens, we're not, is common law real? What's the story with that, like, you have 2 people who live together for 10 years?
No, not really.
So there's no rights?
No.
Not in the state of
Not in the
Florida.
No, not
state
in
of
Florida.
Florida.
Not in Florida.
So, what happens in
California,
cases?
yes.
Right,
Joe
California.
and Jill are married, and
Well, they're not married.
they're married.
They live together.
Forever.
Yeah.
And he dies, what does she have to do? There's no kids? So
Yeah.
it might be like a cousin who receives, the house.
Yeah.
Could be, yeah.
Wow.
Yeah.
Unless there's a will.
Unless there's a will, or if she's on the deed.
There's gonna be a lot of divorces.
One more
No,
thing.
that is entitled.
One more thing about the contract, the only other thing, so, we've got the personal representative, once we've got the personal representative appointed, and again, we talked about how you're gonna have the contract say, Justin Stivers as personal representative, the sale of the property is usually gonna have to be approved by the court, okay? And so, again, this is probably the attorney's realm, but in that, little info section on the contract, or additional terms, or additional information, there you go. I normally just put, again, I try to keep it very simple, but something like subject to court approval. like
Yes,
sale subject to
always.
court approval, something like that. Because again, you just don't, you want the buyer knowing that it's gotta be approved by the court. You don't want them saying, oh, but you promised us closing in 30
No.
days, 60 days, whatever, and then coming after the estate or anything. So something, again, whoever you use, you know, your attorney can look at it and draft something. I normally say something very simple, subject to court approval, see case number XXX, whatever, just to keep it relatively simple. This may be a question.
In reference to,
This question,
Yep.
okay?
how about
Even
if that,
though the person is on title.
Then
You're
normal.
on title.
Then they're on title.
No issue.
Yeah. Title basically trumps everything else. So this is a little, I don't normally say this, but a little off topic, but, so let's say there's a will, okay? And John and Jane are on title, okay? John and Jane own the property as joint tenants with registered registry. But John does a will saying, I leave my house to David. Title wins over the will.
course.
Even though he had the will, Jill gets the house. Or Jane, I don't remember. But yeah, she gets the house. All right, so now, what do you think? I mean, the most common question I get, or that you'll probably get from your potential client, is how long does probate take? How much does probate cost? Those are the most common questions I get. Sounds like you've had a really long one. There's two scenarios that kind of determine how long, in my experience, a probate should cost. Again, you know, we've got one right now where there's a ton of siblings in Israel, and they're like 85, 90, and it's just like they don't want to sign anything. I tried to do a process server, but they're in like Gaza, so it's like no one's getting, you know, it's very difficult. So that's like taking a little bit longer. But for the most part, the numbers or the time frame I'm going to give you is what it should be. All right. So the first thing that determines it is when the person died. So it takes a little bit longer if the person died within 2 years. It takes a little bit less time if the person died more than 2 years ago, and I'll explain why. But the first example, if the person died over 2 years ago, so let's say we're opening the probate right now, 2019, but the person died in 2015. Okay, so he died more than 2 years ago from the time that we're opening the probate. On average, it takes us, or should take, you know, most firms, about 2 to 4 weeks from the time of opening the case with the court to get the personal representative appointed. On average. Could be a little bit shorter, could be a little bit longer. Each county is different, each judge is different. This is just, you know, average 2 to 4 weeks more or less to get the personal representative appointed. And what can you do when you've got the personal representative appointed? Now you can list the property, go to sell the property, market the property, do whatever. So, month 1, we've got the personal representative appointed. Month 2, you guys are off to the races, sell it, you know, do whatever you want. And then, you know, so in theory, it should only take about 2 months more or less to get the property sold, assuming you have a buyer and all of that. Now, there's a distinction if it's homestead. If it's the homestead property, we don't need court approval. So does everyone know what homestead is? We're familiar? Okay, so basically it's the primary residence. So whoever is their main residence. If it was a homestead property, you all don't need court approval to sell it. You need a document from the court that says order determining homestead, and that's basically the new deed. And have you dealt with that? Okay, so in theory, if it's a homestead property, it should only take about 2 months to sell the property, if the person died more than 2 years ago. Good? Okay, now if the person died within 2 years, so let's say he died in 2018, we're opening the probate right now, it's gonna take a little bit longer. So, month 1, we get the person appointed personal representative. Now you guys are off to the races. You can go to market, sell, do whatever. But there's a 3-month waiting period that we generally have to wait. There are some exceptions. I'll talk about those. But usually, month 2, month 3, and month 4, we've got to wait for what's called a creditor period. And so what that is in Florida is if John had any outstanding bills to Baptist Hospital, if he had credit card debt, ambulance bills, whatever, they have a 3-month window after the personal representative has been appointed. They're going to come to us, the law firm, and say, hey, John owed us $2,000. And we deal with that. You know, that's not for you guys to really know. But just know that during those 3 months, most courts, most judges most, systems aren't gonna let you all sell the property. You can go ahead and market it. You can go ahead and try to list it, go under contract if you want. Again, have your attorney review it and say subject to court approval and whatnot, but just know during those 3 months, most likely the court is not gonna let you sell it, or the court is not gonna give you that piece of paper saying order determining homestead. So you gotta wait those 3 months, so we got month 1, 2, 3, 4, month 5, now you all can probably sell it and do all of that. Now, there are some exceptions, sometimes, and again, this is completely court, county specific and judge specific, it's not across the board, but sometimes the judge, if you say, hey, listen, judge, this property is in foreclosure, we're about to lose it, we gotta sell it right away, if, the attorney knows what they're doing, they can present that argument to the judge, and a lot of times, sometimes the judge will allow you to sell it, and then you just put that money into a restricted account. You all still get paid, but the money for the sale, the proceeds from the sale are gonna be held in a restricted account. That doesn't happen all the time, but if there's an emergency, we did one recently in Broward where for tax purposes they needed to sell it and they let us do it. Again, it's just kind of judge and court specific. But if the person died over 2 years ago, you're looking, or within 2 years, it's about a 5-month wait.
And the cost?
And the cost. Okay, so each I would say attorney, everyone does a little bit different. All right, so in Florida there are really 3 ways to charge. The first is hourly, which most people hate. First, our firm, we only do hourly if it's litigated, if we've got siblings fighting and we don't know what the cost is going to be. But sometimes you can charge hourly. The second way is some firms will charge a percentage, up to 3% of the value of the estate. This could work favorably or unfavorably to your client because you might have a $1 million estate that was really easy and doesn't warrant this, $30,000 for whatever $1,000 dollar fee. So we don't do that either, but sometimes it makes sense. And then the last way is flat fee, which is what we generally do, is a flat fee basis. And I would say on average, on the lower end, you're probably going to have a probate around the $3,500, probably on up to 8,000 or 9,000. That's more or less the range for most probates, apart from siblings fighting and all of that sort of thing. Yeah. Okay. So that's the, and I'll wrap us up here in a second. So that's the only thing about cost I would say, because I've had some I think it's fair to give a price range to the clients, but you don't want to kind of lock that person that you're going to use into it. I always say it's kind of like if I'm going to send you a referral and I say, oh yeah, but he'll put his commission 1%. You're going to be really pissed when they say, he said he would do it for 1%. I mean, maybe you would, I don't know, but each situation is a little bit different. I mean, I think all of us, we're not really selling a product. We have a service, so each situation is a little bit different. But I think it's fair to give a range, just so they know. Okay, so then just a couple quick, I guess.
I got a question over there.
Yes. Oh yeah.
Yeah, does your flat fee include all the costs
Yes.
related?
Yeah. Yes.
Thank you.
You're welcome. So, marketing for, again, I said in the very beginning, I think this is a great niche. Now, I've only met one realtor who she does almost exclusively probate, and she's just been in it for a very long time. She gets most of her business from attorneys. She does a lot at the Dade County Bar Association. They do what's called a probate guardianship luncheon once a month. She sponsors that sometimes. If this is an area, I would highly recommend that you all attend those. I don't attend them because it's other probate attorneys, so I'm never going to get any business from probate attorneys. So I don't know. But for realtors, it's all probate attorneys. And again, for one realtor out of how many realtors are in Miami?
Well, the 3 counties is 47,000.
Right. So you have one competition. That's a lot better than all the mailers and everything that are going out. So I highly recommend it. It is it's like all of our business. It's relationship based, so networking with other attorneys is probably a great way to find it. Another kind of cool tool that I've stumbled across, which I don't see most people doing, but if you go to the property appraiser's website, this is really only for Miami-Dade, it doesn't work for Broward, but in Miami-Dade, if you go to the property appraiser's website, in the owner's name, if you go to the owner's name and you just type estate of, and you hit search, you're gonna get a list of 100, 200, it's not all of them, I don't know how they do it, but you're gonna get a fair amount of properties that are owned by estates, okay? Then you could use that list to door knock, to do mailers, however you want, and, you know, the one thing about this area is you are dealing with someone who's passed away, so it's not just, hey, we buy cash home, you know, we all cash buyers, whatever. You do wanna add a little bit of like empathy, yeah, sympathy to it. Yeah, yeah. You know, but you can say, I think it is fair that a lot of times, you know, cause my clients, it's a lot of times the first time they've ever dealt with an attorney, so they don't know what to expect, they don't know what to do. Excuse me. So you could say, hey, whether you wanna use the word specialized, you know, or whatever you wanna say, I work with a lot of, you know, probate properties. You may not know that you'd have to go through probate, I can help you with this, we're familiar with the process. And a lot of times, like, you'll find clients who don't even know that they need to do probate. So again, you're educating this potential client, standing out from the other competition, and you've got a really good list that most people probably don't know about. So that's like a cool little, I don't know if anyone's doing that yet, but I think it's a good way to build a list. So that's probate. And then just last little thing about us, we do also, the only other thing we do is we do write wills and estate planning documents, power of attorneys. I've got, if any of you all are interested, I've got kind of like a price sheet of how much we do for our estate planning packages. These ones are specifically for realtors, so basic will plan is $5.99, $7.99, $9.99, you know, pretty cost-effective plans for the entire thing. And then, yeah, that's pretty much it. If you guys have any other questions or anything?
I'll do a picture. I was a banker for a long time, some of you might know. And the most effective thing you can do for your family members, especially the mom that the father passed away, is put them in an enhanced life estate. It's not an expensive process, especially with there's kids. There's no tax issue. The county works it quickly, and it solves a lot of problems. You know, he said, you know, the numbers, I'm gonna be devil's advocate. I've seen horrible estates, but I've dealt with money and families fighting, you know, money, the house gets sold and that money might not move from that account for years. But if you have an enhanced life estate, I don't know,
Yeah.
$1,000.
That's great, yeah.
And it just moves over, or a little trust or something like that, and you know exactly what happened. Especially if there's a kid who has special needs, or the younger kids, or people who have a religious preference. You know, I want my kid to go to a private school that's Catholic or something. All of those little things can be taken care of, and it's not a lot of money.
Yeah.
And
It's worth it.
You get a lot of brownie points for your money.
I think that's great. I think one thing, you know, I try to do in my business, and I, you know, think you all probably do as well, is you don't want to just be just the probate attorney, just the realtor. You probably want to be like the go-to person for if your client has, or, you know, has any issue. Like, you want to find them a roofer, you want to find them an insurance agent, all of that. So you could go the extra step and say, you know, listen, in this process I've learned a little bit about your family. I think this might be a good thing to do for you. And you know, again, you're not the ones doing it, but you can facilitate and send them to people. One thing, just because you mentioned bank accounts or being a banker, another thing where we get a lot of probates is, and it's sad, sometimes, especially older people, maybe the husband had an account, and maybe it's a second wife, or vice versa, but they're not both on the account. And then one of the person passes away, and now the wife, the husband, whoever, they can't go access the money because the bank has locked the account. So it's, you know, whether you say that for your client, maybe that might be too forward, but for your personal knowledge, it's always a good idea, at least your spouse, assuming you trust your spouse, have them both on the account. Or you can name beneficiaries on your account, and that would be a way to avoid probate as well. You could POD, and there's ways to name people so that it passes automatically without going through probate. But thank you all. Happy to answer any other questions. Oh yeah, one last thing. All right, so these, if you're interested in wills or trust services that we offer, grab a sheet there. I didn't ask, but if you have a business card, it's usually going to do a small raffle. So drop your card in here real quick.
What did you say to go to a meeting where, to meet